Hello and welcome to Courts Today by Live Law. Let us get to today's top legal updates. The Supreme Court today adjourned suo motu case on Arjikar rape and murder to January 29. The Apex Court today delivered split verdict on Tahir Hussein's plea seeking interim bail for Delhi elections. In the Krishna Janmabhoomi case, the Supreme Court has extended stay on High Court's order for commission inspection of the Shahi Idgah Mosque. The Baroda Cricket Association has approached the Supreme Court against a decree to pay 64 lakhs to a senior advocate as fees. The top court has reserved judgment on a Christian man's plea to bury his father in a Chhattisgarh village. In the farmers' protest matter, the Supreme Court has noted positive developments on protesting farmer Dalewal accepting medical aid and farmers agreeing for talks with the union. And the Delhi court has ordered seizure of offensive M.F. Husain paintings on Hindu deities from Delhi Art Gallery. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the end and don't forget to like, share and subscribe to our channel because your support means the world to us. The suo motu case of the brutal rape and murder of a doctor in Arjikar Hospital in Kolkata that occurred on 9th August last year was today listed before the bench of CJI Sanjeev Khanna, Justices Sanjay Kumar and KV Vishwanathan. Senior Advocate Karuna Nandi, appearing for the Association of Junior and Senior Doctors, had mentioned the matter, which was listed as item number 42 on the list today. But due to paucity of time, it was adjourned and has been listed now on 29th January. The updates so far in the matter are that earlier this week, a sessions court in Kolkata's Selda sentenced the prime accused Sanjay Roy in the matter to life imprisonment after he was convicted under Bharatiya Nyaya Sanhita for rape and murder of the trainee doctor. Also, on the last hearing, the top court had noted that National Task Force, which was constituted to give recommendations to enhance the security cover for health professionals, has submitted its report. It asked the states and union territories to give their responses to the NTF recommendations. The NTF has been asked to give its final report within 12 weeks from today. The court also asked AIIMS to consider a plea raised by certain doctors to not consider the period of their protest as abstention from duty in terms of the relief earlier granted by the Supreme Court. In an important update, a two-judge bench of the Supreme Court today pronounced a split verdict on the petition filed by Delhi riots case accused Tahir Hussain seeking interim bail to campaign for the Delhi Assembly elections. Hussain had approached the top court challenging the Delhi High Court's order, which refused him interim bail and granted only a custody parole to file nomination to contest from the Mustafabad constituency to Delhi Legislative Assembly. In the judgment delivered, while Justice Pankaj Mittal dismissed the petition, Justice Ehsanuddin Amanullah allowed Hussain the interim bail. Justice Mittal observed that the right to contest in elections is not a fundamental right. Also, that his right to contest the elections had been protected by the High Court's order granting custody parole to file nominations. Justice Mittal observed that allowing interim bail on this ground could open a Pandora's box, as every under trial would take this ground. That release on interim bail for canvassing will amount to allowing the accused to go for door-to-door canvassing and hold meetings in the locality where the crime took place and the witnesses reside. Thus, a high possibility of the accused meeting the witnesses. Justice Amanullah, on the other hand, while acknowledging that the allegations are grave and serious, stated that they remain as only allegations at the present moment. On the point of 5-year period under custody undergone by Tahir Hussain and the fact that bail has been granted in other cases, Justice Amanullah stated that interim bail can be granted till 4th February subject to the conditions in sections 482 and 484 of BNSS, both of which deal with bail. In view of this divergence, the registry was directed to place the matter before the Chief Justice of India, either to refer the matter to a third judge or a larger bench. Stay tuned for further updates. Moving ahead, the Supreme Court has today extended interim stay on the order of Allahabad High Court for inspection of the Shahi Idgah Mosque by a court commissioner. The bench of CJI Sanjeev Khanna, Justices Sanjay Kumar and KV Vishwanathan was considering the appeals filed by the Mosque Committee challenging the Allahabad High Court's order. The petitions are filed against the High Court order by which it transferred to itself the suits from Mathura Court and the further order allowing appointment of a court commissioner to inspect the the Shahi Idgah Mosque. The matter will now be listed in the first week of April. Another petition is also pending before the Supreme Court, challenging another order of the High Court dismissing the plea of Shahi Idgah Masjid filed under Order 7 Rule 11 of CPC. This plea had challenged maintainability of the 18 suits filed by the deity and Hindu worshippers seeking removal of the Shahi Idgah. The Mosque Committee argues that the Places of Worship Act barred these suits. The Baroda Cricket Association has approached the Supreme Court challenging a decree asking it to pay over 64 lakhs to senior advocate Srinivasan Ganesh towards professional fee. This order was passed by the Delhi High Court in August last year. A bench comprising Justice J.B. Pardewala and Justice R. Madhavan of the Supreme Court urged the parties to settle this matter. To give you a brief background, earlier in November 2024, the court had stayed the execution of the money decree to the tune of 64,35,000. The dispute is regarding the appearance of the senior advocate in a tax case involving association before the Supreme Court. The association claims that except for a preliminary conference held via Zoom at the instance of K.C. Mehta & Co., the association's chartered accountants firm, there was no engagement of senior advocate Ganesh. The association further claims that the matters were finally concluded without the appearance of the senior advocate for any hearing. Although there was no engagement of the senior advocate, he logged in for the virtual hearing without any instructions. Later, the association's CA firm received invoices towards the appearance fee. The association argues that it never instructed the senior advocate to appear and contends that the order does not reflect the appearance. In 2022, the senior counsel had filed a summary suit before the Saket District Court against the association for recovery of the amount. The association filed an application seeking leave to defend, which was granted. The senior counsel then approached the Delhi High Court challenging this order granting leave to defend to the association. Then last year, the Delhi High Court set aside the District Court's order granting leave to defend. The High Court also decreed the summary suit and observed that K.C. Mehta & Co. acted as an authorized agent of the association, and when they had engaged the senior counsel and approved the fee, they could not evade its obligations. Well, the association has now approached the top court. Stay tuned for further updates. And now let me tell you about a case where a son has approached the Supreme Court for burial of his father's dead body. As per the petition filed by him, the man is a tribal Christian from Chandwada village in Chhattisgarh. His father died on 7 January due to prolonged illness and old age illness. He faced opposition from villagers when attempting to bury his father in the local Christian burial area. Despite the family reporting the threats to the police, they were pressured to take the body out of the village. As a result, the body has been lying in the mortuary since then. The petitioner stated before the High Court that the village graveyard has separate sections for tribals and other castes with an area designated for Christians where his relatives were already buried. However, the High Court declining his petition noted that no separate Christian burial ground exists in the village but is available 20 to 25 kilometers away in another village. So now he is before the top court challenging the order of the High Court. At the previous hearing, Solicitor General Tushar Mehta, appearing for the state of Chhattisgarh, had stated that the body could be buried at the state's expense but 20 kilometers outside the village where there is a burial ground for Christians. Mehta clarified that the village burial ground is only for Hindu tribals as per their rituals. He claimed that this position is supported by statutory rules. He further argued that the issue should not be decided on emotions as the intention is to make this a precedent to be followed throughout India. Also, let me tell you, as per the state's counter affidavit filed in this case, any person who has forsworn the traditions of the community or has converted to a Christian is not allowed to be buried in the village graveyard. Today, the Solicitor General, along with State's Advocate General, filed a new affidavit and emphasized its arguments made in the last proceedings. He argued that it is a matter of public order for the state and therefore it has to be handled sensitively. The state also objected to the petitioner's alternate prayer to bury his father in his own private land, saying that burials can take place only at designated places. Senior advocate Colin Gonsalves, appearing for the petitioner, contended that the state's counter affidavit makes it clear that they have admitted the fact that petitioner's relatives were buried in the village graveyard. He took the court through revenue maps and argued that there are many cases where the Christian tribals have been buried in the village itself. He further said that this case is treated differently because the person was converted. Gonsalves argued that this is patent discrimination which has resulted in communalism of the dead person. The bench of Justices B.B. Nagratna and Satish Chandra Sharma questioned as to why a person who had lived in the village should not be buried there, and why, for so long, no objection was raised against those Christian tribals that have been buried. The court also expressed its concern about the lack of dignity afforded to a dead man, that state and the High Court had been unable to resolve the issue, and that the man was forced to come to the Supreme Court to bury his father. Well, today the Supreme Court has reserved the order in the matter. Stay tuned for the verdict. Taking note of the fact that Punjab farmers leader Jagjit Singh Dalewal, who had been on a hunger strike since 26 November last year for MSP and other issues, has agreed to take medical aid, and that the protesting farmers have agreed to hold talks with the union government, the Supreme Court today kept in abeyance the contempt proceedings initiated against Punjab government officials over not shifting Dalewal to hospital. A bench of Justices Surya Kant, Dipankar Datta and Ujjal Bhuya was today informed by Advocate General of Punjab Gurminder Singh along with Senior Advocate Kapil Sibal for the state of Punjab that Dalewal and other farmer leaders have accepted medical intervention after a high-level deputation from the union government met the protesting farmers on 18th January. The court expressed that it is hopeful that Dalewal will take care of his health to pursue his cause. And lastly, a Delhi court has ordered seizure of 2 paintings of Indian painter M.F. Husain on Hindu deities from the Delhi Art Gallery after a complaint was lodged by a lawyer alleging that they were offensive in nature. Judicial Magistrate First Class Sahil Monga of Patiala House Courts allowed the application filed by complainant Amita Sachdeva under Section 94 of Bharatiya Nagrik Suraksha Sanhita, seeking a direction on the Delhi police to seize the paintings in question. In a tweet, Sachdeva had said that she clicked pictures of the paintings last month and filed a complaint at Parliament Street Police Station. She alleged that there were nude paintings of Hindu deities. She said that during a visit with the investigating officer concerned, the paintings were removed and it was claimed that they were never displayed. She alleged that the Delhi police had not registered an FIR against Delhi Art Gallery and its directors for exhibiting the offensive paintings. Earlier this month, the court had noted that IO had already seized the CCTV footage and the NVR of Delhi Art Gallery. As per Delhi Police's action taken report, it was mentioned that a list of paintings was provided by the Delhi Art Gallery. It further stated that the exhibition was held in a private space and the paintings were only to display the original work of authors or the artists.